Think California privacy compliance starts in 2028? That mistake could leave your company exposed before an audit even begins. Risk assessments are already required, and for the largest businesses, the cybersecurity evidence period begins in January 2027. California is no longer asking whether you have a policy. It is asking whether your controls work and whether you can prove it. In this video, we break down who is in scope, what triggers an assessment, and what executives need to know before signing under penalty of perjury.
Today, we're talking about California's new CCPA privacy rules, specifically the risk assessments companies now have to conduct for higher-risk uses of personal information, and the cybersecurity audits that will put security programs, executives, and boards under much closer scrutiny.
So this is not another conversation about rewriting a privacy notice.
No, this is about whether a company can prove that it understands how it uses personal information, has considered the risks, and has security controls that actually work. The regulations took effect at the start of 2026. Risk assessments are already required for new covered activities, and California has said it will begin auditing selected businesses during 2026.
Which makes the line, "We have until 2028, a little misleading.
Very misleading. 2028 is an important reporting deadline. It is not when compliance starts. For some large organizations, 2027 is the first year their cybersecurity controls will be formally audited. The evidence has to exist while the work is happening.
You can't rebuild a year of evidence just before the report is due.
You can try. It won't be a pleasant audit.
All right, there are two requirements here. Let's separate them.
A privacy risk assessment examines a particular activity involving personal information. The business asks, what are we doing? What information is involved? What could the effect be on the people concerned? And do the benefits justify the risk after safeguards are applied? The cybersecurity audit is broader. It examines the overall program for protecting personal information.
So the risk assessment asks whether a particular use of data should happen. The audit asks whether the wider control environment can be trusted.
Exactly. A risk assessment must be completed before certain new processing begins. The triggers include selling or sharing personal information, processing sensitive information, using automated technology for significant decisions, carrying out certain forms of profiling, and using personal information to train some automated or biometric systems.
The word sharing is going to catch companies out. Someone hears that and says, "We don't sell customer lists."
Then somebody checks the website and finds advertising pixels, analytics tools, and third-party software sending identifiers outside the company. California uses sharing in connection with cross-context behavioral advertising. The business may call it digital marketing. The legal analysis may call it sharing personal information.
And sensitive information is broader than medical files and bank details.
Much broader. It can include precise location, biometric identifiers, communications content, information about children, ethnicity, religious beliefs, union membership, and other highly personal data. Employee, applicant, contractor, and business contact information may also count. There are exemptions for certain regulated information and particular activities, but they are often limited. A healthcare or financial services company should not assume its entire organization is outside the law.
So saying, "We're regulated elsewhere" is not a scope assessment.
No, it's the beginning of one. The risk assessment also has to describe the real processing. We use information to improve services is not enough. The company should explain the purpose, the information involved, where it comes from, who receives it, how long it is kept, and what the person has been told. Then it considers the possible negative effects,
which go beyond a data breach.
Right. The assessment may need to consider discrimination, financial or reputational harm, unwanted surveillance, manipulation, loss of control, or using information in a way that a reasonable person would not expect.
So the question is not only, could someone steal this data? It is also, what could our own use of it do to someone?
Exactly. And the processing may be lawful, profitable, and technically secure while still creating a serious privacy risk. Someone with authority has to participate in the decision about whether the activity proceeds and what safeguards are required. This is not supposed to be a form completed by the privacy team after launch.
Although we both know that will happen.
It will, usually with the words, "The business has already committed."
Always a good start.
For processing that began before 2026 and continues today, businesses generally have until the end of 2027 to complete the assessment. New covered processing needs to be assessed before it begins. Assessments also need periodic review. If a material change creates a new risk, increases an existing one, or weakens a safeguard, the assessment may need to be updated within 45 days.
That may be harder than writing the original document. A vendor changes its service, engineering adds another data field, marketing finds a second use, retention moves from 90 days to 3 years. None of that may be described internally as a privacy project.
But any of it could make the assessment inaccurate. Privacy has to be connected to product change, procurement, and system change. Otherwise, the assessment becomes a description of a system that no longer exists.
What eventually gets submitted to California?
For assessments conducted in 2026 and 2027, the first submission is due in April 2028. The business provides required summary information and an executive attestation. It does not routinely submit every full assessment, but the regulator or attorney general can request the underlying reports. So they should be written with the expectation that an outsider may read them.
Candid but disciplined.
Exactly. Clear facts, clear judgment, and no unsupported reassurance.
Now the cybersecurity audit. Who is in scope?
First, the organization must qualify as a business under the CCPA. The current indexed annual revenue threshold is $26.625 million, although there are other routes into the law. For the cybersecurity audit, one route is earning at least half of annual revenue from selling or sharing personal information. The other combines the revenue threshold with data volume. At least 250,000 consumers or households whose personal information was processed in the previous year, or at least 50,000 consumers whose sensitive information was processed.
And those numbers can build quickly once you include website visitors, employees, applicants, contractors, and different business units.
Yes. Companies often underestimate the total because they count only active customers. A very precise number can still be based on an incomplete inventory.
What is the audit timetable?
It is phased by revenue. Businesses above $100 million are first. Their initial audit covers the period beginning in January 2027, and the first report and certification are due by April 2028. Businesses between $50 million and $100 million follow 1 year later. Covered businesses below $50 million follow in 2030.
So for the first group, preparation is happening now.
It should be. An audit of 2027 requires evidence created during 2027, access reviews, vulnerability scans, patch records, training, incident exercises, vendor assessments, risk acceptances, and remediation tickets. If those activities happen only in meetings, there is very little for the auditor to test.
A policy is not a control.
And a control without evidence is difficult to defend. The auditor can be internal or external, but must be qualified, objective, and independent. The same person should not design the control, operate it, prepare the evidence, and then present themselves as an independent assessor.
No grading your own homework.
Right. And the auditor cannot rely mainly on management saying, yes, we do that. Take privileged access. The policy says access is reviewed quarterly. The auditor will want the account population, review records, approvals, removals, and evidence that exceptions were resolved. For patching, the auditor may compare the stated deadline with vulnerability scans, tickets, deployment dates, and formal risk acceptances.
That's where the difference between policy and practice becomes visible.
Very visible. The audit reaches across authentication, encryption, access management, system inventories, configuration, vulnerability management, logging, network defense, software development, vendor oversight, retention, incident response, and recovery. It is risk-based. California is not requiring every company to use the same technical design, but each organization needs to explain why its controls are appropriate and show that they operate.
Can an existing security certification be reused?
Yes, where it is relevant. But the company needs a proper crosswalk. What does the existing review cover? What does California require? Where are the gaps? Does the auditor meet the independence standard? Does the report include the required findings and remediation information? Where certified is evidence. It is not a complete answer.
What is filed after the audit?
The full report and supporting records are retained for at least 5 years. The routine annual submission is a certification that the audit was completed. It is not the full audit report. A member of executive management has to sign. That person must be directly responsible for compliance, understand the audit well enough to provide accurate information, and have authority to submit the certification. The executive attests under penalty of perjury that the information is true and correct, and that the business did not try to influence the auditor's decisions.
That last part changes the atmosphere.
It should. The executive is not certifying that the company has no weaknesses. A credible audit will find issues, But the report must document the gaps, their status, and the remediation plan. That creates a record of what the organization knew and what it intended to do.
And if the same weakness appears in an incident a year later,
Then people will ask when it was identified, who saw it, what deadline was agreed, whether funding was provided, and why it remained unresolved. The audit does not punish imperfection. It exposes fiction.
that may be the line leadership needs to hear. A company can survive a difficult finding. What is harder to defend is pretending the finding does not exist.
Or leaving it unresolved without a documented decision. Recent enforcement makes this very practical. In one 2026 case, a major vehicle manufacturer agreed to pay $12.75 million over allegations involving the sale of precise location and driving information. The case was described as California's first enforcement action focused on data minimization.
Meaning information collected for one reason cannot quietly become available for another use just because the company already has it.
Exactly. In another case, a large entertainment business agreed to pay $2.75 million after opt-out requests allegedly failed to stop data sharing across connected services and devices.
The consumer thought they had opted out. The system treated the choice as applying to one service or one device.
And that shows why privacy compliance is now a technical assurance issue. A button can exist. The notice can look correct. The workflow can still fail.
Click the button. Watch the network traffic.
Test different devices. Test logged in and logged out users. Send the browser opt-out signal. Check the mobile application. Check the advertising tags after a marketing update. And preserve the evidence.
There is also a growing litigation angle.
Yes, the CCPA does not give consumers a broad right to sue over every privacy failure. Its express private action remains largely connected to certain qualifying data breaches. But plaintiffs are testing other legal theories when opt-out technology allegedly fails. A website says, "Reject all." The user clicks it. Tracking allegedly continues. The claim is then framed under wiretap, privacy, or consumer protection law.
So this is not a settled expansion of the CCPA's private right of action.
No, the theory is still developing, but the operational lesson is clear. Do not promise that tracking will stop unless the technology actually stops it.
What should leadership do now?
Confirm scope using current thresholds and actual data volumes. Identify processing that requires a risk assessment and connect that process to product launches, procurement, and system changes. Map the cybersecurity program against the audit requirements. Find where the evidence is weak. Test a few controls from beginning to end. And choose the executive signer early.
Not 2 days before the deadline.
Definitely not. That person needs regular visibility into findings, auditor independence, remediation delays, and unresolved disagreements. The board should also know who owns the requirement, whether the auditor is genuinely independent, which material weaknesses remain open, whether remediation is funded, and whether public statements match the internal evidence.
Because that is ultimately what these rules are testing. Not whether the company can produce more documents, whether it can explain what it knew, what it decided, why it decided it, and what happened next.
Exactly. 2028 is not the starting line. Risk assessments are required now. Regulatory audits can begin now. And for the largest covered businesses, the evidence period begins in January 2027.
So the most expensive words in the room may be, "We thought we had more time."
Those words do tend to age badly.
Cheerful as always, Matt.
I work in cyber risk. This is cheerful.
That explains a lot. We'll leave it there. Thanks everyone for joining us for this conversation. See you all next time in the control room.